Maybe police court, counsel. In 1995, Calvin Matlock was convicted of sexual abuse in the third degree and sentenced to an indeterminate term not to exceed 10 years. Prior to his discharge, the state filed a petition under Iowa Code Chapter 229A alleging Mr. Matlock to be a violent sexual predator. And on July 19, 2001, a civil jury returned a verdict that he suffered from a mental abnormality, that being antisocial personality disorder, and that he be committed to the Civil Commitment Unit for Sex Offenders, CUSO, until such time that he no longer suffered from that mental abnormality. In 2006, because of his treatment progress, Mr. Matlock was transferred to the Transitional Release Program, which is housed in CUSO. In that program, he gained the privileges and had a job, drove to and from work from CUSO by himself, and maintained that job until 2013, where he was granted a final hearing again on an annual review for discharge. Judge Schubach ruled that the state did not meet its burden and that Mr. Matlock was more likely than not to commit a violent sexual act and ordered him discharged. However, on November 7th, he did order Mr. Matlock released with services, essentially adopting the state's plan, ruling that it was in the best interest of the community. Now, again, Mr. Matlock objected at the hearing, stating that it was imposing release with services violates a finding that he no longer suffers from a mental abnormality and thus violates his due process. Basically, again, they came up with a plan that had 30 or so pages, or 30 or so conditions. He was to be supervised by DOC, and he's still supervised by DOC as we speak. If any violated any of those conditions, he could then be returned to the CUSO program, the secure side, without that finding of a mental abnormality. Because Hendricks says you can't commit someone unless you have a mental abnormality and a dangerousness. Because Selby was adopted, the same rulings in Hendricks, that you can't commit somebody without that dangerousness. We don't see, Mr. Matlock objects because you can't hold him because he doesn't have that mental abnormality anymore.
Addington, I think this appeal raises some pretty serious issues. I agree with you. We have Hendricks that upholds the confinement when there's the actual SVP determination that's been made. But now we have still restrictions on liberty, but the person no longer has been found to have the mental abnormality and the combination of that and the future dangerous. My question is, has any other jurisdiction weighed in on these circumstances? Because I have to believe in other jurisdictions you have something like this, supervision with a release or transitional release. Have any other courts weighed in on how do you apply the constitutional considerations in this kind of realm in between discharge and actual full-blown confinement?
And I'm not aware of any at this time.
Couldn't find any either, and that's why I'm asking.
One of the problems is that it took us 15 years to get to the point where we could start arguing over this. I think other jurisdictions are coming into probably the same time period, because our statutes, one of the oldest, Kansas is older, but ours is right in there, 1999. So, and then I don't know what the release is on the other ones. It wasn't part of the original statute. It was only amended in 2002 when they thought, well, maybe someday we'll be releasing people. You know. So, but I'm not aware of any. But the key factor, I think, is if you go back to Fuchsia, where you have to have a showing of dangerousness, and Hendricks and in Selby. We're missing that key element of dangerousness and mental abnormality in order to restrain their liberty. And, the state argues that it's not a big deal, it's just a little bit of restraint. Well, I asked Mr. Curtis how little restraint it is. Again, the same thing could happen to Mr. Matlock. He was supposed to have a review hearing in 6 months under Judge Schubat's order. He had that in about 9 months, and a different judge ruled that it should remain for another year, and will review it in another year on the state's evidence that Mr. Matlock just hadn't made enough friends. That's why they didn't think he should be released at that time, or completely discharged. The trouble is, when we go into the best interest of the community, it's just too vague. We need once we make a determination he doesn't have a mental abnormality, that is the end of the argument under Hendricks, because we can't commit him on the front side. How do we hold him on the back side without that finding of mental abnormality and dangerousness? Now, the state also argues, again, a continuum in this matter, where he might be 40% dangerous. Well, he might be 30%, he might be 20%, but again, the statute calls for a dangerousness of 50.1%. If we don't have that, then the statute should fall on a due process claim. No more further questions on this. I think on the basis that he could not be committed without the dual finding of mental abnormality and dangerousness.
Could I ask one?
Sure.
Before you sit down? Could we rescue the statute through construction by coming up with criteria to better define or give the trial court some guidance on what best interest of the community means? We try to interpret statutes so that they are constitutional. You mentioned that provision is too vague. Could we clear it? Could we rescue it?
I don't believe you can rescue it, Judge Warnerman, because the inquiry should stop once you make a determination that he no longer has a mental abnormality. Once a jury or judge makes the determination that he is no longer dangerous, that he no longer has a mental abnormality, the obligation of the state then it ceases, and the only thing they can do is release him. They can't hold him because they don't have that nexus of dangerousness and mental condition.
And is your argument for that view constitutional, or is it just that the earlier provision, Section 8, trumps the later provision?
No, it's constitutional on the basis of due process. They can't commit him without a constitutional basis of due process, which includes that dangerousness and mental abnormality. They should not be able to hold him because of the due process, that nexus they need between dangerousness and mental abnormality.
I always try to resolve the statutory issues before reaching the constitutional questions. Would you agree or disagree with the state's view that Matlock is a committed person within the meaning of Section 9A? I mean, once you're found a committed person, does that status persist even beyond a judicial determination at the annual review that you don't currently have that mental abnormality? Do you become no longer a committed person within the meaning of the statute?
Only because he's still under the jurisdiction of Counsel as a committed person, but I do not believe he has a mental abnormality, and I believe that it was unconstitutional to consider him a committed person once it's found that he doesn't have that mental abnormality. Does that answer your question? Thank you. For these reasons, we ask that.
I still have a couple of other questions.
Well, sure, Judge.
You've got plenty of time, I guess. But I guess my real question here is, the standard is you have to say that the person was committed then he no longer suffers from a mental abnormality which makes him more likely to engage in predatory acts constituting sexually violent offenses. So are you equating that definition with dangerousness or the benefits for the protection of the community? Are you saying they're like mutually exclusive? So if you make that finding, then you're not allowed to make that secondary determination that even though he's less likely to do a sexually violent offense, are they mutually exclusive that I can't then say that but I think he still continues to be a danger to the community? Are they mutually exclusive then? I think that's what you're saying then.
I am saying that. Not only, you read the definition of 229A2 under definitions, this 5, but then you also have to look at 11 under those definitions, which is a sexually violent predator means a person who has been convicted of or charged with a sexually violent offense and who suffers from a mental abnormality, which makes the person likely to engage. And because once you have a finding that he's not likely to engage, I don't think you have a mental abnormality. You might have a mental condition, but the trouble is the statute sets it at 50.1%, and if we have a continuum, does 10% mean that we should have all these conditions on him? Does 5%? Does 3%? I don't think you can have a continuum down. And so once he does not meet the definition that got him committed, then I don't believe we can hold him any longer. For these reasons, I ask that the statute be declared unconstitutional and the ruling of Judge Schubatz giving him release of services be overturned. Thank you.
Thank you as well, Mr. Addington. Ms. Kraemer.
May it please the court. The constitutional requirements require mental illness or mental abnormality and dangerousness. The definition of mental abnormality that Iowa uses in 229A is a function of statute. It's not a constitutional requirement. So the 51% more likely than not formulation is not a product of the constitutional law in this area. It's a statutory interpretation of the law of Iowa. And we would suggest that there was evidence in the case for Mr. Matlock that he still has mental issues, he has a brain injury, he still has diagnosis, and that he still is a risk. He's still dangerousness. Dr. Thomas testified to those facts in both hearings, and that's the factual basis for asserting that.
And that's a potential argument, but that really isn't what the statute seems to say. The statute seems to say that even if all the experts came in, and I agree that's not this case, all the experts came in and testified that Matlock was cured, he was no longer a risk to the community, et cetera, the court could still, under the release with supervision, decide it's in the interest of the community to put him on this probationary status, this release with supervision, and I'm going to go ahead and do that. And so the question is, how do we construe the statute to make it constitutional to conform with the requirements of Hendricks? Because we're not just deciding this case, we're really trying to give some guidance, as you put in the last argument.
And guidance would be appreciated. I think that confinement is a significant factor. And if you look at the constitutional cases in this matter, they all speak in terms of confinement. And so we would suggest that release with supervision is not confinement, and that's a factual basis on which to distinguish the law in this area. Also, Your Honor suggests a facial unconstitutionality argument, and my understanding is that it would have to be unconstitutional for all sets of facts in order to be facially unconstitutional. We're trying to put on evidence of dangerousness and of continued mental issues that would support the application of release with supervision in a constitutional way.
The court didn't make any, the standard in the statute is in the interest of the community. And what you're suggesting is maybe we could construe in the interest of the community to mean there has to be some ongoing evidence of some level of risk. Is that kind of what I'm
I would
hearing?
agree with that. I think that's true.
Have you found any cases from other jurisdictions with similar statutes that would help us here?
I have not.
Do you have, other than a finding of some ongoing or current risk or dangerousness, can you suggest any other criteria that we could read into the best interest of the community provision to give guidance to the lower courts?
I think the central holding of Faucha, or however you want to say that, is really what I think the guidepost is, that the nature of the commitment bears some reasonable relationship to the purpose for which the individual is committed. And here, the release with supervision plan is individualized. It's tailored to what the individual needs. Mr. Matlock he's actually doing pretty well, and he's been stepped down in terms of supervision as he's had success in the community. So he no longer visits with his probation officer weekly. It's less frequent. And the issue, Mr. Addington construed it as not having enough friends. The issue is he doesn't have anybody in his life but the professionals who are paid to work with him. And so the concern is that if you take that tool away, that there will be nothing. There will be no supports for him. But certainly he's not in danger of revocation. He has a job. He's doing well. And the supports are really helping him succeed in this manner. And if there is no release with supervision, there's no ability to offer those things. He's just out. And so we would suggest that the nature of the outpatient, I think it's analogous to an outpatient commitment, which Iowa has for mental health as well. It's also similar to probation in some respects, which also has a lesser restriction on the individual's liberty. And so hopefully the court will save the constitutionality of the statute looking at those factors. Actually, if there are no further questions, I think I've said my piece.
Thank you, Ms. Kraemer. Rebuttal, Mr. Addington?
Police court. Again, the state would have you adopt some kind of continuum, and I don't understand that continuum once you drop down 50%. First of all, Mr. Matlock was committed in 2001, so he has been under civil commitment for 13 years. For 6 of those years, he was in transitional release program. Now, transitional release has at least a connotation that they're transitioning to something. Again, but then when we get to 2013, they say he needs more supervision because he might be a risk to reoffend. Well, might be a risk to reoffend isn't what the statute calls for. We can only commit someone not on whether they might someday have a 10% risk, but only when they are over 50%. If we can't commit them on that, I don't see how we can hold them on that. And to say that it's just not very restrictive, there's lots of hoops he has to jump through. He doesn't want to do that. And to say that his supports are what's allowing him not to reoffend, how do we know? How do we know if we just didn't release him after 13 years of treatment, after 6 years in transition release, he wouldn't have just done fine on his own. So, you know, this continuum thing makes no sense once we make a determination that he doesn't have a mental abnormality. It's unconstitutional to then figure out other ideas on why we should hold him. That ends the matter as far as due process goes, Mr. Matlock's due process. For that reason, I ask that the statute be overturned on constitutional basis. Thank you.
Thank you, counsel. The Matlock case is submitted, and we'll next hear the arguments in the Didinger case.